Zhang and Shrimpton.
May it please the court, counsel's name is Miss Wang, and I appear for respondent with my learned junior, Mr. Maier-Grant.
Thanks to Wang, Mr. Fairweather. All right, Mr. Zhang.
May it please the court, I will address the first issue of whether Justice Winger erred in finding that the no oral modification or the non-clause could not be revoked orally, and therefore the oral variation was not effective. Your Honours, this is a case about a friend who agreed to an oral variation and is now, after regretting his decisions, attempting to invoke the law to deny the enforcement of that agreement. Your Honours, Justice Cardozo, in his celebrated speech in Beatty, once said, "Those who make a contract may unmake it." Every such agreement is ended by a new one which contradicts it. Whenever two men contract, no limitation self-imposed can destroy their power to contract again. Therefore, it is my submission that the parties' non-clause in this case can be orally revoked. I will develop this submission in two stages. Firstly, by making submissions on the correct approach to revoking non-clauses, and secondly, I will submit on these facts the parties' clear intentions to be bound means the non-clause have been impliedly revoked. My third submission is that, in the alternative, Lord Briggs's necessary implication test should apply and was met on the facts of this case. Before I begin, Your Honours, would you like a brief summary of the facts?
Oh, I think we're pretty familiar with those. Thank you.
Your Honours, I submit that Justice Winger erred in finding that the non-clause could not be revoked orally. I will develop my first submission in the following two ways. Firstly, I will outline and justify what the correct approach is. Secondly, I will explain why Lord Sumption's strict approach in the United Kingdom Supreme Court in Rock Advertising is not tenable, as it is heavily relied upon by the respondents. Your Honours, it is possible to revoke orally a non-clause. The correct approach to the enforcement of non-clauses is to objectively assess what the intentions of the parties were when they entered into the variation agreement. Under this approach, non-clauses are considered as a piece of evidence to be considered with the entire factual matrix holistically to determine what the parties' true intentions were. This was also the approach taken by the High Court in Conqueror at paragraphs 43 and 46. If the court is satisfied that the true intentions of the parties were to be bound by the oral variation, then the non-clause no longer has any legal effects to deny the enforcement of that intention. Your Honour, the governing principle here is party autonomy. The correct conception of party autonomy means that Mr. Nadir and Mr. Hawthorne are free to bind themselves, but it also means that they are free to unbind themselves, and that is clearly reflected in Justice Cardozo's speech in Beatty. Under this correct conception of party autonomy, the existence of a non-clause is relevant to determining the party's intentions, but is not determinative.
Counsel, can I just ask you a question on that? Doesn't respecting party autonomy require that we give effect to the language and the terms that they adopted, which regulate the manner in which they can vary or modify their agreements? And doesn't your approach just really read down what is quite clear contractual language?
Yes, Your Honour. I believe that Counsel submits that this question directly touches on Lord Sumption's strict approach to enforcing non-clauses, and it is through that reasoning that His Honour took that strict approach. However, I respectfully disagree, because what is really at play here are the two competing party intentions. The first being the intention of the parties to agree to the non-clause, and second, the intention of the parties to enter into an oral variation. And the real question here is which one of those parties' intentions should prevail. And my submission is that it is the latter, in this case, that should prevail. Going back to my first submission, Your Honours, under the correct approach, there must be evidence on a balance of probabilities that the parties intended to be bound by their oral variation. Therefore, the existence of a non-clause serves to indicate the parties' intentions, original intentions at the formation of the contract, but Mr. Nadir may produce compelling evidence to displace that original intention. Your Honour,
Mr. Zhang, do you not see any advantage in having an approach similar to Lord Sumption's in the Rock case, given that the difficulties that can arise when there are arguments about what was truly agreed or not agreed? That seems to me to be the main commercial justification.
yes, Your Honours, I submit that non-clauses do have commercial benefits, and we should not be disregarding those commercial benefits.
Well, don't the parties then disregard it themselves when they come to make a variation
Yes, and
that is not in writing?
yes, Your Honour, I submit that for whatever reason that the parties initially had in mind to contract the non-clause, whatever commercial benefits they might have had in mind, later down the line where they agree to the oral variation, it must have meant that the parties thought that those commercial benefits were no longer as important. And it is not for the courts to delve into the true reasons, but to accept that as face value. Your Honour, this correct approach, the intention approach, strikes the best balance between upholding contractual certainty and contractual autonomy. This is because this approach recognizes the commercial reality that parties may agree to restrict themselves to certain formality requirements, but also recognizes that parties are able to change their minds as their commercial positions change. This was a view that was endorsed by Lord Briggs in his minority judgment in Rock Advertising.
That's where he had all the rest of the House of Lords against him, didn't he, on the Supreme Court? But one of the justifications that Lord Sumption put up for his approach was that the parties could rely on the equitable doctrines of waiver and stop and get around the harshness of the rule that he proposed.
Yes, Your Honour, I submit that despite the equitable doctrines being a safeguard, it is still my submission that Lord Sumption's strict approach is untenable conceptually, and this is where I move to my next submission. Your Honours, my learned friend at submission 5.6 quoted Lord Sumption that the correct conception of party autonomy means that once parties have agreed to restrict their autonomy, freedom to contract is restricted within that autonomy. With respect, Your Honour, this conception of party autonomy cannot be true. And that was discussed earlier when I outlined there were two competing intentions, and it makes more conceptual sense to enforce the latter intention when the parties have shown a clear intention to be bound. One of the reasons why that is the case is because the latter variation is the best indication of Mr. Nadir and Mr. Hawthorne's most recent intentions in time, and that intention being to revoke the non-clause. Your Honours, if Your Honours would allow me to illustrate why Lord Sumption's approach should not be adopted through this hypothetically. Your Honours, non-clauses, broadly speaking, are merely a clause that places formality requirements on variations. If this is accepted, then one can imagine that a clause which imposes a formality requirement that is so onerous in substance makes the contract unmodifiable. Does it not defy logic that parties can contract for an unmodifiable contract? If this court applies Lord Sumption's approach, then it must mean such a clause would also be enforceable. I submit that this simply cannot be true. Such an outcome would be inconsistent with the fundamental principles of contract law that parties can contract freely. Your Honours, I further note that my learned friend at submission 5.4 submitted that by pointing to the widely used international codes, it is somehow justifies a strict approach to enforcing non-clauses. Your Honour, we respectfully disagree. That disagreement is based upon distinction between statutorily imposed non-clauses and non-clauses that parties voluntarily agree to under the common law. In the latter, as long as one or both parties intend the non-clause to be effective, then it will serve to deny oral variations. But if it can be shown that the parties no longer intend for the non-clause to be operative, then there are no reasons conceptually why oral variations cannot be binding. When it comes to statutorily imposed non-clauses, the starting point is not the party's intentions. Therefore, this analogy is not one that should be used to justify the strict approach.
Mr. Zhang, on the question of analogies, would you address the court on the analogy drawn by law assumption between the enforceability of entire agreements clauses and non-clauses?
Yes, Your Honour. Law assumption invoked the entire agreement clause as an analogy to justify the strict approach. I submit that that is not a good analogy. Entire agreement clauses are wholly backwards looking. They determine the party's intentions at the time of entering into that clause, restricting the party's intentions to what was agreed at that point. However, non-clauses are forward-looking. They restrict the party's variation, conduct by variation or oral in the future, and it is my submission that the non-clause cannot be analogous to entire agreement clauses. Rather, it is more appropriate to see the oral variation as the analogy, not the non-clause. Your Honour, for the reasons that I have submitted, law assumption's strict approach is untenable conceptually. Your Honour, I also note that my learned friend, in the written submissions at 6.2, argued that not enforcing non-clauses would strictly preclude the commercial benefits that it confers. Those were the benefits that were invoked by law assumption at paragraph 12 in his judgment. Your Honour, there are two reasons why this court should put very little weight on the commercial benefit that non-clauses confers. The first was already addressed previously, where even if the party didn't have in mind good intentions or the practical benefits, commercial benefits in mind, for whatever reason they must have thought it was not as important when they agreed to the later oral variation. Secondly, when the courts are faced with a conflict between conceptual clarity and upholding public policy, commercial benefits, it is my submission that conceptual clarity ought to prevail. If there are no further questions, Sean, I'd like to move to my second submission.
Could I just clarify the argument you're advancing here? Do you acknowledge that there are significant commercial benefits to non-clauses, albeit outweighed by conceptual clarity, or do you say that the benefits are in any case just overstated?
Your Honour, it is my submission that if commercial benefits are valuable, they should be recognized, and adopting the correct approach strikes a balance between upholding commercial benefits and also party autonomy. So it's a win-win situation. Your Honour, we submit that under this correct approach, the oral variation agreed between Mr. Nadir and Mr. Hawthorne was effective because they had impliedly agreed to revoke the non-clause. Whether the non-clause had been revoked by the oral variation is to be ascertained with reference to the true intentions of Mr. Nadir and Mr. Hawthorne. That is the correct starting point. Mr. Nadir must establish on the balance of probabilities that the agreement reached over the phone conversation on the 13th of April was intended by the parties to be legally binding. Your Honour, at paragraph 14 of the Moot High Court's judgment, the phone conversation showed that both parties were aware of the existence of the non-clause. Mr. Hawthorne had in mind the non-clause when he said, "We should meet to write this up since the contract requires any variation to be in writing." However, despite this, Mr. Nadir had intended to revoke the non-clause when he said, "My friend, can't we just agree now? If we both agree, what does it matter what the contract said originally?" Mr. Hawthorne's response showed that he had reciprocated that intention when he said, all right, I agree." Furthermore, before the phone conversation, Mr. Nadir had approached Mr. Hawthorne on the 1st of April to discuss that variation. I submit that a reasonable person in Mr. Hawthorne's position who had in mind a contrary intention would have informed Mr. Nadir of that intention within the 13 days that had lapsed. The fact that Mr. Hawthorne had failed to take steps to inform Mr. Nadir of his intention to enforce the variation in writing points towards the intention to revoke the non-clause.
Do you draw any distinction between revoking it entirely for all time or just waiving it on this particular occasion?
Yes, Your Honour. I would draw a distinction. If the parties can be shown to expressly revoke the non-clause entirely, that is a possibility. However, on the facts of this case, it was only brought to the minds of the parties, so it must only be impliedly revoked for that variation. I submit that on the balance of probabilities, established on the facts, the parties had intended for the oral variation to be binding despite the non-clause. If Your Honours accept this, then Mr. Nadir is not liable for the claim of 50 hours. Turning to my third submission, Your Honour, we submit that alternatively, Lord Brooks' necessary implication test ought to apply, and we further submit that on the facts of this case, it was met. Your Honour, Lord Brooks, at paragraph 29 to 30 of his judgment, describes the necessary implication test as being, in times of emergency or necessity, the courts can infer that there is an implied departure from the non-clause. His lordship held that necessity arises in a situation where the orally agreed variation called for an immediate performance. If that immediate performance is different from the obligations that the parties originally contracted for, and written record of that variation could not be made and signed, then courts may infer an implied revocation of the non-clause.
Mr. Zhang, on the facts of the case though, surely it would have been possible to enter into an express written revocation electronically.
Yes, Your Honour, and that is exactly the points that my respondents have raised. However, we respectfully disagree, and on that basis, I draw the distinction between a variation agreement that terminates contractual obligations and a variation agreement that is within an ongoing commercial contractual relationship. On the facts of this case, it is the former. Mr. Nadir, through agreeing to the variation agreement, had thought that his contractual obligations to Mr. Hawthorne had finished. It therefore follows that it would be redundant for Mr. Nadir to make a text, email, whatever written, whatever variation that is to be put under written format, and deliver it back to Mr. Hawthorne, because that's redundant, no matter how easy that would have been.
I'm not quite sure for the parties to enter into a variation of writing and sign, simply exchanging the signed written document electronically. Do you disagree that that was possible, or do you say that it doesn't matter that was possible?
Your Honour, it does matter. However, on the facts of this case, counsel, I'd adopt a different interpretation of the facts, and that was not possible. There are no further questions, Your Honour. That is the case for the appellant. Thank you.
Yes, thanks, Mr.
May it please the court. The case before us today concerns a written variation made in a time of emergency and financial difficulty. The issue in this case is whether such a variation requires consideration to be valid, and if it does, whether good consideration was given in this case. The law of consideration is fraught. However, legal principle, policy, and authority all indicate that consideration is no longer required for a contract in the general sense or a variation in this case. Therefore, the written variation is valid, the repayment threshold is raised, and the debtor does not owe $480,000. In support of this conclusion, I will put forward 3 submissions. Each submission results in the fact that the written variation is valid. The first submission is that consideration is not required for any form of contract. The following 2 submissions are in the alternative. The second submission is that consideration is not required for a variation in an existing commercial relationship. And the final submission is that the parties obtained practical benefits from the variation which accrued good consideration in this case. Turning to our first submission, that consideration is not required for any form of contract. Under this take on consideration, it is merely part of the factual matrix. In the words of the Court of Appeal in Anton's Trawling, at paragraph 93, it is no more than a valuable signal of party intention. This position is supported by legal principle, policy, and authority. Turning first to legal principle. The most important principle in the law of contract is party intention. A contract at its best is an agreement between 2 or more parties driven by the intention of those parties to have a meeting of minds. Consideration should not fetter the true intentions of the parties. Moving to the second relevant principle, it is unjust and illogical that the giving of something of nominal value in the absence of other good consideration will make a contract valid, but a contract that does not have good consideration will be invalidated by the courts if the parties do not offer something of nominal value. And this unjust principle was acknowledged by Justice Galt and Gloria Jeans in the New Zealand High Court. Finally, and perhaps the overarching principle, is that consideration adds complexity to the law. Therefore, we should do away with it to enable simplicity and logical coherence.
Mrs. Shrimpton, in relation to the ambulance trawling case and the statement by Justice Maier-Grant there about consideration really being a valuable signal to parties' intention to be banned, first question, do you think that that was the intent of Justice Maier-Grant? Do you think that he was making an argument that we should abandon the doctrine of consideration altogether, regardless of the situation of contractual variations?
Yes, Your Honour. In that case, it was unclear what side the justice was saying. Ultimately, he raised the arguments for no consideration, and he raised the arguments that criticized that, but ultimately came to the conclusion that he did not need to make a decision about whether consideration was valid or not, because either way, the same result would be reached. So he left the question up in the air. But the arguments that he raised for the no consideration approach are still valid and should still be adopted.
So you're inviting us, we are not bound by any authorities at all. So we're in a very privileged position, but of course with that comes a great deal of responsibility. Do you think it would be proper for us to take the step that you seem to given the enormous ramifications that this would have for the law of contract?
Yes, Your Honour. In terms of the position of the court, that has been raised by justices in previous decisions. And the reason they haven't chosen to develop the law is primarily because they didn't hear the full issue before the court. They indicated that otherwise they would be comfortable for the decision to be made within the realm of the court. And that was acknowledged by Lord Sumption in the United Kingdom Supreme Court case in MWB Business Exchange. The other side of that is that some justices also raised the point of it being decided by Parliament. In terms of that consideration, the history of consideration is the most important factor. Consideration was born in the common law and therefore should be decided in a common law court, because a common law court knows best the rule and its implications. Additionally, the court is ultimately a court of principle, who understands principles of law and conceptual consistency, whereas Parliament is in the realm of policy and weighing different policy considerations, and the question before us is one primarily of principle.
So you put a number of alternative submissions to us. Which, in your view, is the one that provides the best solution to this particular problem?
That's an interesting question, Your Honour, because I would submit that my first submission and my third submission result in the same practical result in this case, and probably in most cases before the court. If benefit is widened to practical benefit, it's very unlikely you're going to have an agreement where some form of practical benefit or legal benefit can be found, which makes consideration almost irrelevant. And this was acknowledged by Justice Gully in the Gloria Jeans case, where he stated at paragraph 36, practical benefit, it could be argued, is just another way of saying the promiser had a reason for making the promise, which it will almost always have been in the absence of duress, which indicates the no consideration approach, which prioritizes the intention of the parties, is almost exactly the same as practical benefit. Yes, Your Honor. Thank you. So
I think that it's true, isn't it, that even Justice Scott didn't go as far as the proposition you were advancing today.
Yes, Your Honour, but he did acknowledge that there were hefty arguments behind the no consideration approach and didn't take that step explicitly because of his position in the New Zealand High Court, and he thought it should be decided by a higher court. But he acknowledged that the arguments in Anton, Strolling and Teat, which are for no consideration, were for no.
Yes, the Justice Gold also expressed reservations about law moving in that direction. It's almost said that it would be a very large step for them to take, and expressed a reservation that that would take New Zealand in a direction where other common law courts have not headed. Should we, as the Moot Court of Appeal, be concerned about adopting your submission to do away with the requirement for consideration if that moves New Zealand in a step without common law defence?
Yes, Your Honour. First of all, I would acknowledge that Justice Galt said that while it is a large theoretical step, it's not a large practical step, which he acknowledged at paragraph 36. But I do understand your concern with being out of step with other jurisdictions. But ultimately, I think it comes back to the fact that the law can be developed out of step with other jurisdictions if that is the right thing to do in line with principle and policy. And in this case, I have submitted that that is the right thing for the law to do in the right direction for it to take. And in that case, New Zealand might be trailblazing ahead of the other jurisdictions, but that would be the right thing to do in response to the arguments.
And so as against the alternative option of adopting the practical benefit test, can you just articulate why it's the right course for New Zealand to take in terms of the development of the common law to go for the slightly more extreme or slightly purer approach that you might frame?
Yes, Your Honour, and I think you hinted at it in your question. It is the purer approach, and this approach would fix a lot of the problems that have come out of consideration in one fell sweep. There are a variety of distinctions that complicate consideration law, including the difference between deeds and simple contracts, between third parties and original parties, and practical benefit and part payment for a whole sum fox and bear case. Getting rid of no consideration would be the best way to get rid of this complexity and invite simplicity into the court. Yes. Your Honour, as we have discussed no consideration in detail, I'll move to my second submission in this case. However, if you have any other questions regarding that submission, I'm happy to answer those.
Yeah, move on, I think, Ms. Shrimpton, thank you.
Moving to my second submission, that in the alternative, consideration is not required for variation in an existing commercial relationship. This approach, while it is in the alternative, would address many of the concerns that you have raised today. It is not so big a theoretical step. It is simply creating another distinction in the law of consideration. It leaves the consideration principle unscathed and merely refines it in a particular direction. The reason that consideration should only be removed for variations rather than contracts as a whole is for one key reason, and that is because that there is a strong presumption in variations that existing commercial relationship have good underlying commercial reasons, and therefore it's unlikely that something that appears as a gift is actually a gift. There are wider commercial interests that might not qualify for concrete consideration, but nevertheless prevent the dangers of a gratuitous promise. Commercial parties are unlikely to give something away, especially if dealing with competitors. The New Zealand Court of Appeal has expressly endorsed this development of law. Justice Galt discussed this at detail and Gloria Jeans recently in 2020 at paragraph 32. If this approach was applied to the facts before us, the rule would be that no consideration will be required for variation as long as it is agreed voluntarily and without illegitimate pressure. There is no evidence of illegitimate pressure on the facts of the case here, therefore the variation would be valid despite the lack of consideration. This would result in the same result as the first submission. The repayment threshold would be raised and the deal would not owe $80,000 to Wellington.
Ms. Shrimpton, just turning to the facts of the case, you talk in your submissions about an existing commercial relationship. Does it cloud the issue at all that these were good friends and that Mr. Hawthorne may have seen that this concession was given as an act of friendship or to support Mr. Nadir in a personal way? Does that cloud your analysis at all? Does that change anything?
Your Honour, that does not change the relationship simply because an act of friendship or wanting to retain the friendship could be a practical benefit that Hawthorne could gain. Therefore, it would perform the same purpose as a variation in an existing commercial relationship, where Hawthorne is doing it for larger reasons than just performing a gratuitous promise in this case.
So is it your submission that there was a commercial motive here?
Yes, Your Honour, my submission is that there was both a commercial motive and a friendship motive. If you turn to my submissions at 9.8, you'll see that I outline 4 different practical benefits of the transaction. 2 of them are commercial and 2 of them are based on friendship. I will turn to the beginning of my third submission, that the parties obtained practical benefit from the variation, which accrued good consideration. Therefore, the variation is valid. Again, this is supported by principle, policy, and authority. And beginning with legal principle, there is a distinction between benefit in law, which is a promise, and a benefit in fact, which is an act. The traditional view required that a benefit or detriment to be good consideration must exist as a legal benefit or detriment. However, the modern approach has widened this so that practical benefits or detriments can also be considered good consideration. It is my submission that that view should be adopted. It takes a pragmatic view of the relationship and is no principled reason why practical benefits should not fulfill consideration as much as legal benefits. Practical benefits fulfill the idea underlying consideration itself, and that is of reciprocity. Turning to policy, Acknowledging practical benefits takes account of the material commercial advantages that most commercial parties contract for. Most commercial parties do not contract for abstract legal benefits, but for concrete practical benefits that they can measure while they are going about their business. Additionally, it balances enforcing promises and enabling debtors to rely on their creditors' promises with protecting creditors from debtors who seek unfairly to gain an advantage from their creditors. Finally, in terms of authority, practical benefits have been accepted as good consideration in New Zealand. This is in both Anton's Trawling, Teat and Wilcox, and recently Gloria Jennings in New Zealand High Court. The rule in this case, if this position is adopted, would be that promising to perform an existing contractual obligation is good consideration if it provides a practical benefit and is not given as a result of economic distress, duress, or fraud. And this is taken directly from Williams and Rocky at page 15.
How do you distinguish the Folks and Beer case?
I distinguish the Folks and Beer case on two different facts. First, Folks involved the repayment of debt, whereas this case involves not only the repayment of debt, but the allocation of profits, which gives the contract a completely different nature.
So you would read Folks and Beer down?
Pardon me?
You would read Folks and Beer down to confine it to its own effects?
Yes, Your Honour, and that is the approach that has been taken by justices to make it compatible with Williams and Rocky, notably in NWB Business Exchange in the UK. The other fact that Folks can be distinguished on is that it involved part payment and satisfaction for the whole, but this case involves merely moving the payment threshold. Returning to my discussion of applying the practical benefit test to the facts. In this case, there's no evidence of economic duress or fraud, and practical benefit to Nadir is not questioned, so that leaves the only question to be...
So can I just pause you there and just focus on these practical benefits. In terms of the continuation of the business, the respondents in their submissions have taken issue with the fact that there's no disclosure of any contrary intention. What significance, if any, should we place on that?
Your Honour, first I would note that that's simply incorrect. On the facts, Hawthorne explained to Nadir that he is adjusting the payment threshold not only so he could have more money to help his father, but also so he could pursue his dream. There's no other way to construct the term as to explicitly saying, I expect you to continue the business because I am doing this to enable you to pursue your dream. Regardless of whether that phrase was saying or not.
So could you just take me to the reference in the judgment below so I can get the
Yes, Your Honour, it's at 9. 9-4.
I see.
Thank you, Your Honour.
And my related question is the second categories of benefits that you've listed in your written submissions of paragraphs 9.83, the preservation of friendship, and 9.84, the support of a friend's father. I wonder in the context of old friends who have intertwined a business relationship, whether we should really think of this as a practical benefit rather than just, on one view, the emotional manipulation by one friend to another.
That's an interesting view, Your Honour. On the facts, there's no evidence of emotional manipulation. Nadir asked to be excused from his obligations and was upfront saying that he needed to support his father. He did not push this in any way that seemed to be pressuring Hawthorne or anything of that sort. On the contrary, Hawthorne agreed to help Nadir of his own accord and in a sense of raising the repayment threshold instead of getting rid of the obligations. So there's no evidence of emotional manipulation in that case. In terms of friendship being a practical benefit, I think practical benefit is such a broad principle that it must take emotional benefits or friendship benefits or relationship benefits into account. It's not confined merely to commercial benefits. The true context of the parties, including their long-standing friendship, must be taken into account when making that calculation. Thank you, Robin. In the interest of time, my third submission shows that there are clear practical benefits to both parties. There's good consideration in the very.
The conflict in the present case is between contractual autonomy and contractual certainty. The appellants have argued their case on the former. However, I will submit that both concepts support the validity of non-clauses. I will do this first by submitting that Justice Winger did not err in finding that non-clauses cannot be orally revoked, that the intention test from the New Zealand High Court decision of Concurrent International must be overruled. And finally, I will submit that if Your Honours prefer Mr. Lord Briggs' minority judgment in rock advertising, the facts do not meet the necessary threshold to find the variation valid. We invite the court to dismiss this appeal. Turning to my first submission, a non-clause cannot be orally revoked, either expressly or by implication. This will be explored in two parts. First, that Justice Winger was correct in applying the 2018 United Kingdom Supreme Court decision of MWB Business Exchange Centres and rock advertising. Further, that the New Zealand authorities support my submission. Writing for the majority, Lord Sumption and rock advertising held that a non-clause cannot be orally revoked, either expressly or by implication. As a result, oral variation in the presence of a non-clause is not effective. The purpose of contract law is to facilitate the voluntary undertakings of parties. Lord Sumption at paragraph L states that the law of contract does not normally obstruct the legitimate intentions of businessmen except for overriding reasons of public policy. Yet, there is no mischief in non-clauses, nor do they frustrate or contravene any policy of law. The question now is whether the parties had legitimate intention in agreeing to the non-clause. We submit that they did. Non-clauses have legitimate value. Oral discussions have the potential to undermine formal agreements by informal means. A non-clause would be of clear value to the parties in this case. They have a strong personal relationship. The frequency of informal contact is high. The non-clause would ensure that personal contact would not vary the commercial agreement, and this would ensure contractual certainty. Further, limiting the form of variation for a more considered and formalised variation, this would help keep their personal and their business matters separate. Written variation provides the opportunity for parties to more deeply reflect and make more considered decisions when compared with a casual variation between friends. On the present facts, the alleged variation occurred within a personal and a commercial conversation. The non-clause would protect the parties in this position as it gives them more time to consider their decisions, particularly the commercial impact of their decisions. And finally, non-clauses also limit legal disputes. A non-clause would make it clear what is valid and what is not. This clause was intended to protect their relationship by avoiding such long and lengthy litigation. As the non-clause in the 30th of November 2007 contract was likely a legitimate intention between two parties, with no issues regarding public policy, the court must give effect to this clause. Conceptual inconsistency.
Just on the face of it, is a rather unattractive argument on the facts of this case, where the parties immediately acted on their whole agreement by paying the money and handing over the keys and effectively bringing the relationship to an end.
I submit that the parties erred in not giving effect both parties could have taken more commercial considerations into account. Looking to the facts, the conversation, there was a sense of urgency imposed on Mr. Hawthorne by Mr. Nadir, which would have prevented him from seriously considering the commercial impacts and prioritising his need to help a friend. However, the very fact that this clause exists suggests the fact that the parties did want that extra level of protection in order to take more commercial considerations into account. Does that answer your question, Your Honour?
Yes, so far as it goes. You've got Lord Briggs against your view. How do you respond to his approach?
Our response is that Lord Sumption has the correct approach, and that Lord Briggs's approach, although more flexible, makes non-clauses redundant. And that because they're making non-clauses redundant, that goes against the contractual autonomy of the parties. They're essentially telling parties that they cannot bind themselves to a form of variation to which both parties have agreed. The only way to give true effect to non-clauses is through Lord Sumption's view, which is that non-clauses cannot be orally revoked.
So, how do you respond to that apparently harsh position?
We submit that the harsh position can be mitigated by waiver and estoppel, in particularly unconscionable situations.
That's all right, thank you.
Turning now to conceptual inconsistency, which is a common argument against giving effect to non-clauses. However, the reality of the law indicates that arguments on inconsistency are invalid. Widely used international codes give effect to non-clauses, for example, the Vienna Convention on Contracts for the International Sale of Goods, 1980. And further, Lord Sumption rightly states at paragraph 15 that non-clauses do not forbid oral variation, they merely render them invalid. The 13th...
Well, that's a rather artificial distinction. Fact is they can't be enforced. So effectively, they're not appealing.
But this is addressing the conceptual inconsistency argument, which at its core is a theoretical argument, and he has responded correctly with a theoretical answer.
Yes, well, I think you're probably getting some impression that we're not too convinced by some of Lord Sumption's conceptual arguments.
The 13th of April 2019 conversation is the type of situation against which the non-clause was intended to protect. As I said previously, the conversation blurred the personal and commercial relationship. It occurred due to urgency imposed by Mr. Nadir, and despite acknowledging the requirements for the form of variation, the parties agreed on variation. Where the parties had a non-clause in mind but chose to vary them anyway, Lord Sumption at paragraph 15 would describe such a situation as courting invalidity with their eyes open.
Although isn't there another way to look at it? The very fact that Mr. Hawthorne is aware of the no oral modification clause is nonetheless prepared to verbally agree, and would in any case, had the time allowed it, as he said to Mr. Nadir, he was very happy to arrange to meet and sign. So what is the benefit in those circumstances of defeating what the parties agreed in terms of the variation notwithstanding?
As you said, Mr. Hawthorne was willing to meet and vary the agreement through written means. However, that is exactly what the non-clause is, to give Mr. Hawthorne the opportunity to give written variation. There is a material difference between written variation and oral variation, in that the former allows for a more considered approach. Even something as little as sending an email or a text message, Mr. Hawthorne would have that moment to step away from the personal or the heightened personal situation and consider commercial considerations in his decision.
So it's a benefit in terms of a cooling down period, you say, where you can step away from the heat of the conversation and reflect. That's the benefit that we're preserving by giving effect to the non-clause.
That is correct, Your Honour, especially considering their very close personal relationship. Turning back to contractual autonomy, which is another commonly cited argument against oral variation. Lord Sumption at paragraph 11 rightly calls such an argument a fallacy. He states that party autonomy operates up to a point when the contract is made, but thereafter only to the extent the contract allows. Nearly all contracts bind with parties some cause of action, and to that extent restrict their autonomy. The real offence against contractual autonomy is the suggestion that parties cannot bind themselves to a form of variation, even if that is what all parties have agreed. There is no principled reason to prevent this, and this is not a foreign concept in law.
Ms. Wang, could I just ask a question? I suppose this is about legal culture. You rely very heavily on Lord Sumption's judgment in the NZLSA case. Clearly that is a very bright line approach. It's a rather extreme approach. Do you really think that that is appropriate in our jurisdiction, where, to go back to the analogy with entire agreements clauses, the position here in New Zealand, by virtue of statute of course, is that the oral representations or statements will override the written entire agreements clause unless the court is satisfied that it would be fair for that written clause to be conclusive. Is that an appropriate approach in this jurisdiction, or is it that this is a part of English legal culture that places particular importance on certainty?
We submit that this is the correct approach to apply in New Zealand.
Sorry.
We submit that this is the correct approach to apply in New Zealand because what we are submitting is that non-clauses have legitimate benefit, the benefit of which includes contractual certainty,
As to entire agreements clauses.
Which are important in New Zealand culture. However, not giving effect to a not following Lord Sumption's blanket extreme approach in regards to non-clauses would essentially make them redundant. For example, the intentions test proposed by the appellant would essentially open up non-clauses to litigation and destroy the actual benefit in which we derive from them. I do not believe that is the case with entire agreement clauses. They can still have effect because of their backward-looking properties. However, a non-clause would essentially be rendered redundant if we did not follow Lord Sumption's approach. Now turning to the New Zealand authority.
No, it was just an accident. Sorry.
Oh, was it?
Yeah. Sorry.
Now turning to the New Zealand authorities in the 2012 Court of Appeal case, Stevens and ASB Limited, this case also considered the validity of a non-clause. Justice Arnold at paragraph 27 stated that without written variation, the court saw no justification for going behind these plainly worded provisions, which are intended to prevent uncertainty and dispute that so often arises where written agreements are said and to have been varied orally. The most recent New Zealand decision that considered this issue, Conqueror International and Max Gladiator Limited, will be explored in my second submission. Finding that non-clauses are valid would be in line with New Zealand's position on this issue in international treaties. New Zealand has ratified the Vienna Convention on Contracts for the International Sale of Goods, 1980. Article 29, paragraph 2 states that a contract in writing which contains a provision requiring any modification or termination by agreement to be in writing may not be otherwise modified or terminated by agreement. Consequently, the courts should find that non-clauses are effective as it would be consistent with our present international position. As a result, the 30th of November 2017 contract agreed to by Mr. Nadir and Mr. Hawthorne included a non-clause. As non-clauses cannot be revoked orally, expressly, or by implication, the conversation on the 13th of April 2019 was not effective in varying agreement. It is not relevant that the parties acknowledge the non-clause, as the non-clause could only be revoked by writing. If your honours do not have any further questions, I'd like to turn to my second submission. My second submission is that the intention test from Conqueror International must be overruled. In the 2018 New Zealand High Court decision, Conqueror International and Max Gladiator Limited, Justice Gendel stated that the fundamental issue concerns the intentions of the party. This test must be overruled because it is based on overturned law. The judgment noted at paragraph 45 that the English approach was likely applicable in New Zealand, then referring to the United Kingdom Court of Appeal decision in Rock Advertising that allowed for oral variation. This decision has been recently overturned by the United Kingdom Supreme Court decision, which found that oral variations to be invalid. The court must overrule the intention test as a key authority, and Justice Gendel's reasoning is no longer good law.
Well, the moot court of appeal needs to take its own view as to what the principal position should be, and the fact that the decision of Justice Gendel has been overtaken by developments in the case of Frank Court only takes us so far. And my question is, doesn't the decision of Justice Gendel illustrate how a less extreme test might operate in practice, where the court weighs up the evidence regarding intention, and in that case concluded that there was no intention to depart from the no oral modification clause? And my question is, does that arguably dispel the concern that you expressed earlier regarding the potential for abuse or the loss of benefits from no oral modification clauses?
No, Your Honour. We still submit that the intention test must be overruled for other reasons as well, one of which is that it offends contractual autonomy as law assumption understands. The intention test would essentially render non-clauses redundant because you do have to go through the factual analysis of what was said and what was not. These discussions tend to be a he said, she said type of argument within a courtroom. You're not giving effect to a provision to which all parties agree, a provision which, at its core, its benefit is certainty, to which, so you can avoid such lengthy and complicated court cases.
To hear the parties have directly contemplated this particular clause and decided not to follow that and agreed anyway.
We submit that, are you talking about the motivations of bringing this case to the court?
Yeah, no, I'm talking about the motivation to rely or not rely on the non-clause.
We submit that the parties, again, what Lord Sumption would describe as courting invalidity with their eyes open. There was no reason why the parties were both aware of a written variation. Written variation on the facts could be quite simple as a text or an email, yet that they decided not to. And by deciding not to, they knowingly left themselves open to litigation. In our time remaining, in regards to my third submission, that in the alternative, if the minority decision was applied, I defer to my written submission. If Your Honour has no further questions, that is the case for the respondent on the issue of non-clauses.
Yes, thank you, Ms. Mayor.
At the outset, to situate this problem within the broader discussion of consideration And so with the permission of the court, before my main submissions, I'd like to highlight two advantages of consideration that have made it so fundamental and enduring to the common law. The first of which is that consideration is an incredibly useful indicia of intention that allows the courts to avoid a often messy process of trying to determine what is subjective intention, which is anything but simple. If the courts could look into people's minds and tell us whether they intended to agree, that of course would be something that we would welcome. But courts recognize their fallibility and the dangers of open-ended inquiries and rely on certain bright-line tests such as consideration or the formalities of the deed. And the second important advantage is that it forces a meeting of the minds that is the foundation of all contractual certainty, and I will be submitting has not taken place here. I'll submit on two issues. Firstly, that the court should readopt the requirement of a full consideration for contractual variation, and secondly, a submission that should the court retain the practical benefit test from Rocky Brothers, this undisclosed benefit should not be accepted as fulfilling that test. May I move to my submissions?
Yes, sir.
I would submit firstly that there is no meaningful authority supporting the removal of consideration generally. I think that would be an exceptionally bold stance for this court to take. If we were to accept that consideration for contractual formation were still to exist, full consideration, practical benefit, and no consideration form points on a spectrum, turning on the degree to which contractual variation should be considered as separate, distinct to contractual formation. The essence of my submission is that no difference should be assumed, that Justice Wingard did not err in not finding that, and that the courts should respect the fundamental position in Stilk and Myrick that fresh consideration is required to vary a contract. Cases that do depart from the standard, such as Anton's trawling, and say that no contractual, within contractual variation, or in fact within contracts generally should be no consideration, do emphasize that consideration is a signal of intention to be bound rather than an end of itself. And subject to the qualification I gave in my introduction, I take no issue with that formulation of the law. The question that truly follows is whether the existence of a pre-existing contract means that it can be assumed that a variation is intended to bind both parties. In the same way, for example, the formality of a deed or consideration would be a sufficient signal.
I had some difficulty in following that paragraph. Can you just explain it for me again?
Yes, Your Honor. Essentially what I submit here is that in order for us to depart from the idea that full consideration is needed, as it would be in a contractual, the formation of a contract, we would need to there to be some sort of signal that allows us to no longer have to rely on the signals of the formality of the deed or the signal of consideration, and so have it be a sufficient signal in and of itself to be a contractual variation, such as to do away with those requirements.
What are the sort of signals that you're talking about?
Merely in this case, the fact that it is a contractual variation rather than contractual formation. Because in essence, what is submitted by the appellants is that in the case of a contractual variation, we should no longer have to fulfill the formal requirements of a deed or have consideration, which are the two traditional signals that are used by the court.
The proposition that for a variation you could do away with consideration is perhaps quite a startling one, and seems to me to be inconsistent with the present trend of authority, that some lesser standard might apply to variations than to the formation of a contract, and that one can look at practical benefits and so on.
Yes, Your Honor, and this was why I wanted to situate the variations of consideration from full practical benefit and no consideration on a spectrum. To the degree that you accept that we can adopt a different test of practical benefit, which does not reach the full consideration as would otherwise be required, it still turns on the degree to which you assume that contractual variation is of a different nature to contractual formation. I would submit, therefore, as the heart of this submission, that the courts cannot make any assumptions from the fact that it is contractual variation, because consideration, or the formalities of the deed, or the other signals that are used, are active parts of a new contract rather than the mere background to that contract. The first preliminary note to make here is there's nothing essential to an agreement to give up a contractual right, such as Mr. Hawthorne did, than to give up any other right that could be done through a contract. For example, an agreement to give someone ownership of a car is agreeing to vary your property right, yet that we would accept if it is a new contract, requires consideration in order to signal an intention to be bound. The justification, therefore, must be found in the relationship or the circumstances that can be assumed from the fact that this is a contractual variation as opposed to contractual formation. I would submit, firstly, that this variation cannot be, this distinction cannot be found in the relationship, because that would be incredibly difficult to confine to variation alone. If two business partners wish to form a new contract, they have a highly commercial relationship, it makes no distinction whether or not this is a variation or a new contract that is simply part of a long-standing relationship. And of course, while I do not wish to suggest that my argument turns on the fact within these cases, it does highlight that many relationships that do have a contractual foundation also have other foundations. And if you were Mr. Nadir, with no knowledge of this benefit that was being derived by Mr. Hawthorne, your assumption would be that this was done on altruistic or friendship basis, which is very different to the contractual relationship as is supposed by the argument to relationship. But I think secondly, and more important, is that people often make promises to vary contractual rights without the intention to be bound. They are motivated by the same factors that motivate any other non-binding promise. Moral obligation, a wish to understand intention, simple absent-mindedness. And I think what is particularly important is that these are often reasons beyond practical benefit, beyond simply the wish to extract commercial gain. What is often overlooked, especially in this case, is that promises, even when they are unbinding, still have value. They are designed to help forge a common understanding while still preserving flexibility, and may entail moral or equitable obligations on a person that do not intend to rise to the level of being contractually bound. And essentially, if we were to accept that consideration is no longer required for contractual variation, the presumption would then be that almost all promises that have a reason behind them are assumed to be binding. Mr. Hawthorne did agree to change the contract, but I would disagree with the statement that there is evidence in this case to say that he agreed to be bound within a legal sense to following through with that obligation. Even if he had intended to be legally bound, and it could be demonstrated by the counsel for the appellant, this is a highly atypical case. It's not essentially something that we should be founding general principle upon, because in many cases, the purpose of consideration is because parties are often unclear the extent to which they wish to be bound by different agreements.
On the question of intention to be bound in this case,
Yes, Your Honor.
the written variation, which is set out in paragraph 10 of the judgment below, it does seem to me to be expressed in language that is formal and contemplates its binding effects as a reference to the parties agree. And the second sentence says all other terms of the contract remain unchanged. So, could you just help me understand your submission?
Yes, Your Honor. I would firstly note that, of course, while there is a suggestion that they are to be bound, the language never rises to an explicit understanding of that. Many parties can agree to something without agreeing to be bound. Memorandums of understanding are incredibly common, and they often also adopt formalistic language, also often refer to contractual clauses in other that otherwise would exist beyond them. But what I would say particularly is that we adopt a standard for whether to assume intention has been proved from the formalities of an arrangement that already pre-exists, and those are the formalities of a deed. Should parties wish to bind themselves and make it known that they are legally bound, they agree within a certain set of formal parameters to make sure that his intention is clear. What this case does is not only undercut the need for consideration, but also undercut the rationale that we have for deeds. And if it was sufficient to simply express intention, that would suggest that the current system we have of formality for deeds would also no longer be required for variation.
What do you mean when you talk about people expressing intentions in this context? Because I think everybody understands that often people in their conversations don't use specific language to say, I am agreeing that I will be bound by this oral arrangement, and I am agreeing that we shall revoke this or that, or I'm agreeing that do whatever in terms of the contract. And what the courts have to do in this context, isn't it, is to look at the facts as they're presented and draw inferences from those facts as to what the parties must have intended in the circumstances facing the court.
I think that highlights exactly why we should retain the system of consideration in deeds, Your Honour. Many people speak imprecisely when they are making agreements. Many people are not clear the degree to which they want to be bound. So instead of a broad, open-ended, often imprecise, highly discretionary approach that may underline the predictability of contracts or the advice parties could get as to the degree to which they are bound by particular contracts, we instead use broad indicia of whether people are going to be bound by those contracts. The two most traditional indicators are consideration or formally indicating your intention to be bound by going through the process of a deed.
Well, there was consideration here, though, wasn't there? By raising the payment threshold.
There's consideration for one party, Your Honour, but consideration for both parties is necessary for the minds to meet, such as to show dual intention.
Well, I think it was Shrimpton who drew attention to paragraph 9 of the judge's findings, when Mr. Hawthorne has said to Mr. Nadir that the change in the threshold would mean he'd have more money to help his father while still being able to pursue his dream. Now, the court would infer, wouldn't it, that that meant that the contract would be ongoing for the benefit of both parties.
It assumed that the contract would be going, Your Honour, and it assumed that Mr. Hawthorne cared about Mr. Nadir, but Mr. Hawthorne at no point disclosed to Mr. Nadir that his underlying reasoning was to preserve his own profit motivation. And when
it's very unlikely to say that for the reasons that I've just indicated, and I'm just putting to you that on those facts, would it not be reasonable for the court to infer from Mr. Hawthorne's statement about him pursuing his dream that they were both concerned about continuing profitability which each anticipated from this contract?
I would submit, Your Honour, that what can be drawn from this particular fact scenario could give rise to a inference that intention to be bound existed on both parties. I would say, in particular, though, that unless we were to get rid of consideration generally, the distinction between why we should...
That's really not what I'm putting to. I'm putting to you that they both gave consideration in one form or another.
In terms of practical benefits?
Yeah.
If you would prefer, Your Honour, I can move on to my second submission and address that now.
Well, it's up to you as to how you address the argument. It does seem to me that is the case against you on this point.
Yes, Your Honour, and were we to adopt the practical benefit test set out in Roffey Brothers, I would submit in this case that it is incredibly important that we do not extend that test so as to include benefits that are undisclosed to the other party, as that will drive deep fissures into the predictability of many contracts. And there are two arguments that could be articulated here. The first is to say that the benefit that is obtained by Mr. Hawthorne I would argue is exceptionally meager and may not rise to the degree of being a practical benefit as envisaged in Roffey Brothers. In that case, a renewed promise was obtained.
Start's proposition. Do you accept Roffey Brothers' practical benefits as a proposition?
No, Your Honour. I still do not believe that there is a conceptual distinction between contractual variation and contractual formation so as to allow us to disregard full consideration. But that, of course, is the test, perhaps driven by judicial pragmatism, as Tipping J would put it, to adopt that test within New Zealand. And within the strictures of that test, this case, I would still submit, does not fall within that. So the first submission on that point, of course, was that this benefit does not rise to that level, as what is obtained by Mr. Hawthorne isn't any expectation or increased information or assurance from Mr. Nadir that he will exercise his option under the contract in a way that is favorable to Mr. Hawthorne, whereas in almost all other cases, there is at least a common understanding of a benefit that is being brought and some assurance that it is actually, in fact, more likely to be gathered. I would not accept the submission that friendship or altruism is sufficient to be a practical benefit. Firstly, because, of course, courts are incredibly wary to adopt a strict contractual approach to arrangements between parties that is motivated by friendship or family. But secondly, because it is important here that what is articulated is not a benefit, but a practical benefit, and a friendship benefit or a feeling better about a relationship is not practical in the same way that many of the other benefits, or in fact all of the other benefits articulated in the case law are.
Mr. Maier-Grant, going back to the question of practical benefit, why does it matter whether it is disclosed or not?
Of course.
Because if we go back to the facts of Hughes and Roffey, there were a number of factors there. The Court of Appeal didn't tell us precisely which of those factors was determinative, but the Court identified a number of factors. Now, none of those factors were necessarily expressly disclosed. It was clear to the other party that the initiative had come, of course, from the other party in that case, for the continued performance. But why should that invalidate practical benefit, that the failure to disclose it?
In my submissions, I articulate two objections to undisclosed benefits. The first being conceptual, as to whether or not the parties have truly come to an arrangement as to whether or not they are to be bound in the same way as it was disclosed, and the second being a policy discussion. Whereas if a party if a contract from both parties cannot be assumed to be binding or non-binding because it relies on information or benefits that are only known to one of those parties, it becomes incredibly difficult for parties to contractual arrangements to understand whether or not they are bound.
But doesn't it underlie the whole notion of practical or factual benefit that all we're looking for is something that is in fact a benefit?
That is the test as it is formulated in Roffey, but I still do not believe that that overcomes the policy considerations. As to the conceptual basis of whether it fits within that test, I would note that Mr. Hawthorne, in this case, should not expect to be bound, where the benefit that is sought places no obligation or expectation or pressure on another party. But in particular, Mr. Nadir should not expect to bind Mr. Hawthorne to an agreement that seems to be entirely motivated by friendship, entirely motivated by altruism, or motivated by anything that would not even reach the practical benefit.
Can we be satisfied with that fact, though?
We can be satisfied with that.
Subjectively speaking, that may be the case, but of course the court has to look at this objectively. And applying an objective test, do you not think a court would look at that and say the reasonable person would be motivated by the commercial benefit, given this all happens against the background of a commercial agreement, which clearly both parties intend to benefit?
Your Honour, the facts as they are known to Mr. Hawthorne disclosed no increased risk that Mr. Nadir would decide not to continue with the company. While of course Mr. Hawthorne subjectively came to that expectation, I don't believe that is something that can be extended to all reasonable parties. And equally, the fact that Mr. Nadir had not been disclosed this as the benefit, or any reasonable party in Mr. Nadir's shoes would not have equally been disclosed this benefit, means that when a friend seems to be taking significant losses or giving away essentially $80,000 when you've told them that your father is dying, I think the reasonable assumption for that commercial party wouldn't be to assume it's entirely commercially motivated. Your Honor, if that satisfies your questions, such press the submissions.
Yes, thanks Mr. Grant again.